60 Minutes with Angela starts right now.
Of Appeal sitting in Lagos State says that Nigeria's Economic and Financial Crimes Commission lacks powers to investigate and prosecute serving judicial officers except where they have been dismissed by the National Judicial Commission. So is the court saying that crimes by judges should first be handled by a disciplinary commission before the EFCC can step in. Well, hello and welcome to the program. I'm Angela at JITI Ogunye. Legal practitioner JITI Ogunye joins me today on the program. Together, we'll be taking our quarterly look at legal issues in our federation today. Thank you for coming on.
It's my pleasure to be here. Thanks for inviting me.
Let's start with this Court of Appeal matter in Lagos State. The EFCC lacks powers, they say, to investigate or prosecute serving judicial officers except where they have been dismissed by the National Judicial Commission. Please help us rationalize that.
Well, the judgment hit the polity 2 days ago like a thunderbolt. And indeed, I would say that for me, the judgment is a terrible Christmas gift for the Nigerian people and their quest to rid their country of corrupt practices in our public life. I've read the judgment, and as a lawyer, I'm conscious of my professional responsibility not to disagree with a judgment of a court of law by trading insult and abuse. Our duty, and this is a public duty, whether you be a public intellectual or you are just a citizen who is interested in legal developments and pronouncements of our court, our duty is to look at the judgment the way it is and offer a very fair critique of the decisions contained in that judgment. And I start by saying that the judgment is a departure from the settled position of the law.
Which was?
That every public officer with immunity under Section 308 of the Constitution or without immunity can be investigated. That position was settled by the Supreme Court in the decision of Fayemi and IGP. Of course, in that case, which emanated from the issue of certificate manipulation allegation against the erstwhile governor of Lagos State, Chief Gani Fayemi filed an action following the letter I wrote to the Inspector General of Police in that year to insist that there must be an investigation. And of course, the police said that once you are clothed with immunity, you cannot be investigated. But the matter then went through the gamut of the judiciary, and the Apex Court settled it by saying all public officers can be investigated in respect of allegation of crimes or allegation of commission of offenses against them. They may not be prosecuted if they have immunity, but that all of them without exception can be investigated. Indeed, the court went on to say that for certain categories of criminal allegation, it is safer and better to quickly conduct investigation because the pieces of evidence that will be used might be perishable, and that once that investigation is not conducted immediately, then a lot of things could be lost. So for those who have the toga of immunity, that it will be better to conduct that investigation and preserve the investigation so that once the person drops that toga of immunity, then the person can be proceeded against. Now, what the Court of Appeal has decided in this case now is that for serving judicial officers, they cannot be investigated at all, let alone being prosecuted, if they've not been administratively disciplined first by the National Judicial Council. That the judgment held had the absolute right to first discipline a judicial officer before such judicial officer can be investigated or prosecuted. In other words, the decision held that as a condition precedent to criminal investigation by the EFCC or any of the anti-corruption agencies or the police, that judicial officers against whom such a body wants to proceed by investigation or prosecution first must have been stripped of his judgeship by the National Judicial Council before he can be proceeded against. Okay. That's not what our law is saying.
Okay, let me stop you there. 2 points are coming to my mind before we come to the constitutional provision. If the NJC then says they don't see anything wrong with the person's actions, for instance, we know that petitions have been written against a lot of judges, and the NJC didn't see anything coming, any infractions committed. Will the prosecution or investigation against that person still proceed?
No, it will have been stymied. It will have been perpetually stalled. It will have been perpetually truncated. That means the anti-corruption agency or investigating body cannot proceed. That means the NJC has decided on its own that there is no merit in any criminal allegation by, using its jurisdiction in respect of disciplinary action against serving judicial officers for misconduct. The NJC will have used that to then truncate a criminal investigation and a possible criminal prosecution. And that's why I say that the law is being rewritten. As students in the university, we study administrative law. It's a second-year course in the university. And so, talking about administrative law and constitutional law, under our constitution, the power that is exercised by the National Judicial Council regarding judicial officers under section 158 of the Constitution, paragraph 21 of the third schedule, part 1 of the Constitution, that stipulates the powers of the National Judicial Council, paragraph 20 of the same third schedule, part 1, that stipulates the composition of the National Judicial Council. The community reading of all these provisions in the Constitution, including section 153, that establishes the National Judicial Council, and as well as all the other executive body, Federal Judicial Service Commission, Federal Civil Service Commission, and so on and so forth. A community review of all those provisions will show clearly that what the NJC is called upon to do is to deal with the issue of the appointment of judges and the exercise of disciplinary powers over judges in respect of allegation of misconduct. Now, the law also are settled by the decision of the Supreme Court in the case of Gaba University of Maiduguri, decided in 1985, part 18 of the Nigerian Open Law Report, is that the NJC cannot try criminal offenses. So no administrative body can try criminal offenses.
So misconduct is not crime?
It's not crime. It's not crime. It's just misconduct. And so after that administrative body, or before that administrative body would try anybody for misconduct, the anti-corruption agencies can investigate that same person, even if the elements of that allegation of misconduct constitute the same facts of the criminal allegation. And that's why I say that this matter is a rather settled one. Yes. The reason we are familiar is that under the public service rules, if a public officer or a civil servant is facing a criminal trial, he's been charged to court, there is a process which is called interdiction. He is immediately suspended by the Federal Civil Service Commission and at the same level, State Civil Service Commission, pending the outcome of that trial. That's what happened actually to the wife of Justice Ademola, who was the head of the civil service in Lagos.
Yes.
And once that trial started, she was suspended. That's what is called interdiction. So in other words, it is not the law that a criminal investigation or prosecution should abide an administrative decision. That's not the law. Rather, it is the other way around. So when we now see a judgment, holding that what we're not familiar with should now be the norm, should now be the new rule of law, we cannot but be surprised. As a matter of fact, in the law of tort, where people sue people for civil wrongs and all that,
yes,
there's a principle there that if there's a civil action in respect of, for example, assault,
yes,
and battery, and a criminal prosecution is also instituted by the police for criminal assault or criminal wounding,
yes, based on the same fact.
Based on the same fact, that civil action will have to stop, and the criminal action will proceed. It is when that criminal action is then determined that that civil action,
which is what we saw in the case of O.J. Simpson, for
exactly. As a matter of fact, one of our cases in court involving a journalist who was severely injured arising from the Dana airline disaster and all that, one Ben Walaka, the police filed a criminal action. We, acting for the LUJ, had filed a civil action for the enforcement of human rights. But the lawyer on the other side raised an objection, and the judge of Lagos High Court says, you just have to wait until this criminal action is concluded. So the point is that the jurisdiction of the NJC is well defined under the Constitution. There is no provision in the Constitution or in any other law that grants immunity to serving judicial officers from criminal investigation or criminal prosecution, unless and until the National Judicial Council deals with the allegation of misconduct against them first. As a matter of fact, for Nigerians to see how illogical, with profound respect to the judges that deliver this matter, this decision is, some criminal allegations arising from the judicial duty or the exercise of judicial powers, or related to the exercise of judicial powers of a judge, may not attract any petition. For example, a judge could have abused his office arising from taking of bribes, and this may not be obvious to the person against whom a judgment is rendered. So he has no proof.
He can even write
a petition. So it remains in the realm of conjecture. But if an anti-corruption agency gathering intelligence discovers a humongous amount in the account of a judge and traces it to one of the trialists before that judge, a criminal investigation can be initiated and a criminal prosecution can ensue. But what the NJC and this judgment, is now suggested to be done is that, at least by the letter the NJC wrote to the EFCC, which is now in the public domain. And what this is suggesting is that EFCC should now be writing petition to the NJC. And the question I ask is that, look at the EFCC Act. The EFCC Act says that it must receive petition. So you are now requesting a body that is established to receive petition to now be the one writing petition to you, just because you want to claim the power to deal with the judges first and perhaps resolve the matter in the way you feel, to insulate judges from the indignity of being subjected to criminal investigation and criminal trial. It is not right. It is not. That's not what the law is saying.
I'm looking at the larger picture now. Is there a danger that any government official whose agency, ministry, or department has in-house disciplinary opportunity, is there a danger that they too will fall under this and say, look, in my ministry we have a way to discipline unless the disciplinary committee allows it to happen, you can't touch me?
That's the implication and the larger ramifications of this kind of judgment, because it's going to lead to a chain of possibilities. Yes. As a matter of fact, lawyers who currently are being tried allegedly for bribing judicial officers may also hide under this latest judgment to say it's in respect of discharge of our professional duty, and we are alleged to the allegations that we bribe a judge.
Yes.
So this judgment has now come. We have our own legal practitioner disciplinary committee. So if the legal practitioner disciplinary committee does not discipline me first, why should the court? Yes. And doctor, for example, may say, look, we also have our own medical and dental council disciplinary committee.
Yes.
So if we not found blameworthy first by that body, then why should we? And even for the Federal Civil Service Commission, the argument can be made by a public servant or a civil servant that, look, we have this body here, unless and until I'm found guilty and I'm dealt with administratively, you cannot take me to court. So, you know, it is true that a court decides a case based on the facts before it. And a judge is not expected to be swayed one way or the other by surrounding circumstances that may not impinge on the facts of the case. So, however, a judge does not behave like an ostrich. Even the judgment that we are discussing now, there is a reference to what was happening in the polity in the judgment, which the justices said they taking judicial notice of. The justices were making allusion to the practice of the executive in setting up bodies to investigate certain allegations. And they mentioned the National Intelligence Agency matter and the other matter, the serving to the government of the Federation, that they set up that administrative body first to determine whether they were culpable before they then decide that, okay, the anti-corruption agencies can have a bite. Yes. That just as it is in that case, it should also be. So I read the judgment and I just, you know. So overall, our view is that the concept of judicial immunity pertains only to civil liability of the judex in the performance and discharge of his judicial duty. In other words, there is a concept of judicial immunity at law. But what that judicial immunity grants is an immunity from civil liability arising from the performance of the duty of the judge. In other words, nobody, for example, can sue a judge for not judging a case properly, for being dilatory, for wasting time and all that. So the judge is not liable even for the orders that he may give. You can't sue the judge for giving an order that has affected you. You can only appeal. So that is the concept of judicial immunity that we know. And of course, I have stated here, and I've, you know, in our previous editions, that we also have all sort of immunity: diplomatic immunity, executive immunity, legislative immunity, and so on. Just as legislative immunity pertains only to legislative duties and functions on the floor of the House, and it does not relate to the criminal conduct of legislators, which was the reason legislators recently in Nigeria wanted to expand the scope of that legislative immunity to also grant immunity to themselves. Yeah. In the same manner, judicial immunity does not extend to criminal culpability. So what this court has done now is to expand the scope of that judicial immunity by not saying so, by merely saying, well, what's going to happen is that before any judge can be investigated or, you know, prosecuted, the NJC must. Now, the NJC is not a court of law. The NJC does not have the instrumentality, the resources to conduct criminal investigation. It doesn't have the procedure to determine criminal guilt. So there are no prosecutors there, so to speak. You don't have this elaborate process by which you defend yourself and all that, as if you are conducting a criminal trial. In any case, now that this decision has been taken, for us to see how futile it is, if a judge is being investigated for taking of bribe, and the NJC is claiming the power of the sole body to deal with the matter before the matter can be investigated or prosecuted, how does the NJC source evidence? Because if the allegation is that a judge has received money into an account and I'm the judge. I run the account. By fiduciary obligation, my bankers are not obligated under the law to disclose the content of my account to another person, to a third party. And the agency doesn't have the power of summons. It doesn't have the power to compel a bank to yield
that information. Yeah.
So it is only an anti-corruption agency that can do that. So if that evidence is not going to be made available because investigation before administrative disciplinary procedure has now been barred by this government, so how do you then source the evidence? So it is not right. This is not what the law expects. And my worry is that this is being portrayed as a reactive judgment, as a protectionist judgment. You know, that phrase derives from what goes on in Europe and America and everywhere. There are protectionist policies in the agricultural sector to protect their own farmers and all that. So this one is like a protectionist judgment. You say, no, it's like a community or branch of government or sector verdict. So it may be beyond that court. It may be beyond those three justices. And that is the worry. I feel passionate about Nigeria. And I still pray very hard that our social, economic, and political problems are resolved in a civil manner. But when they shut the door to peaceful resolution of societal problems are being methodically and systematically shut one after the other, you are only driving the people to adopt desperate solutions. And you know, the roof of society does not collapse in one day. There will be nibbling conduct gradually. There will be some chiseling, some digging, some breaking. Then eventually the roof will come crashing down.
Join us again after the break. Joined us, it's 60 Minutes with me, Angela at JITI Ogунye. On my hot seat today, legal practitioner JITI Ogунye. Let's talk about this new twist to the case of the Senate President Bukola Saraki. At the Court of Appeal, they've dismissed 15 counts and revived 4 counts 4, 5, and 6, sending it back to the Code of Conduct Tribunal. The court said that there was direct evidence from testimonies supporting these 3 counts. Do you think the timing of this is political? As I've read in some media where they're saying, you know, it's odd that it's coming at this time.
I can't see the oddities. You know, sometimes in the criminal trial, apart from the tribunal, that has the statutory power to determine the matter and adjudicate the criminal matter or the quasi-criminal matter, determining the pace of and the duration of that criminal trial. Lawyers, defense lawyers, prosecution lawyers can also contribute to the case management. For example, in this particular matter, from which the appeal arose, the defense attorneys adopted the tactic of conducting cross-examinations for days with all their battery of lawyers.
Yes.
Asking the same repetitive questions.
Every lawyer came forward.
Yeah, and all that for cross-examination, thereby delaying the matter. So, if the matter that started way back and which ought to have been concluded and wrapped up was now long drawn to such an extent that an appeal that arose from that matter is now being decided now on the eve of the commencement of politicking, so to speak. Why would anybody suggest or insinuate that the timing of the decision is political? It's not political.
Were you surprised though that the tribunal acquitted the Senate President in June of this year, 2017?
I was surprised because I followed the case keenly. The kernel of the tribunal decision was that those allegations were hearsay, basically, because they were claiming that the investigation was not conducted by the Code of Conduct Bureau. It was conducted by other sister agencies, principally the EFCC.
Does it matter?
No, that's what the tribunal does. So it's not, and that's what the Court of Appeal has now decided. You know, drawing a distinction between direct allegations and the ones that are not so direct and all that. Anyway, I expect and one can envision a further appeal to the Supreme Court. If the Senate President decides to appeal, matter further, as I think he will,
Yes.
then there's also the likelihood that the state may cross appeal and even insist that, oh, those charges that have been struck out, by the Court of Appeal were not properly struck out and all that. So it's an interesting time.
It is. I was thinking about this asset declaration matter, apart from the fact that one of the reasons was that it wasn't investigated by the Code of Conduct Bureau itself. Is asset declaration, is it not a strict liability thing? You either declared it or you didn't declare it.
There is a principle of law in the case of Totti and Nakpabi that states that even illegally generated evidence is admissible to establish the commission of a crime.
Illegally
generated evidence, yes. And it's in the new Administration of Criminal Justice Act. It's also reiterated there. If a police team conducted a search of a house without a warrant of arrest, and they got to that house and they saw weapons, drugs, and all that, and they then want to use it, and you are saying that no, there was no search warrant because you think you are silly. What illegally generated evidence is admissible. If you are not a lawyer who is equipped with the resource and the professional tool to understand these things may then make a lot of sense to you. But if you have that tool,
yes,
you just read this judgment and this decision and you just smile. I mean, the legal profession is my profession.
Yes.
The judiciary is my institution. I have, right from when I was younger in the legal profession, done a lot to defend the judiciary, even against the military. As a young man, each time you can find me in those days, leading some of us and other lawyers were talking about why ouster clauses should not be allowed.
Yes.
What do you think they were doing? What they were doing, they were defending the judiciary against the onslaught of the military that shackled the judiciary with jibes and didn't want the judiciary to exercise the plenitudes of its powers under military dictatorship. So we've been defending the judiciary all our professional lives. So when you then see some of this judgment that made you to feel not too happy, you look at it and you smile because this is your constituency, so to speak, and all that. But a lot of people are disappointed at our judiciary. But I think that we'll make it as a country.
I want to take you now to the matter of the former chairman of the Presidential Task Force on Pension Reforms, Abdulrasheed Maina. Your observation that Mr. President cannot lawfully sack Mr. Maina. You also claim that he has ignored those that he can lawfully sack. And these ones are the dramatist personnel within that case. Talk to us about that. What are your reasons for saying that?
The Maina saga is an open textbook now. The drama is still unfolding.
Yes.
Now, when Maina was surreptitiously brought back into the country and then brought back into the civil service, vied the letters that the Honorable Attorney General of the Federation wrote, directing the Federal Civil Service Commission and advising the Office of the Head of Service to reinstate Maina because Maina had a judgment, which was a fundamental right enforcement judgment, having no bearing and nothing with his employment. Because if really he wanted to challenge his dismissal, he would have gone to the National Industrial Court. But that judgment was from the Federal High Court, Abuja Judicial Division, which dealt specifically with the warrant of arrest issued against Maina for failing to heed the 7th Senate summons, and which warrant was nullified by that court because the court felt that all the condition precedents and the basis for the issuance of that warrant had not been satisfied and had not been met. So that specifically was what the case decided. So it had no bearing on the employment. So when the AGF, Honorable Attorney General of the Federation, was now writing, lashing onto that judgment to say it should be given a consequential effect.
Yes.
There was no consequential effect that judgment would have been given. So because the issue at stake was not whether another warrant of arrest was being reissued to arrest Maina. So it's not about the warrant of arrest, it's about whether Maina could be brought back into the civil service. And so when he was therefore reinstated and the news broke and the president then directed that he be sacked, the point of law that will make it was that under the law, the president does not have the power directly to sack
any civil servant. any civil
servant. He doesn't have that power. So, because after that statement was put out and Premium Time used it, Femi Adesina, speaking for the president, then came and then tried to explain the president didn't do that. The president merely directed those who are responsible to do that. Anyway, that's an afterthought. The president does not have the power to directly or indirectly sack any civil servant. That power at the federal level belongs to the Federal Civil Service Commission. And for civil servants and public servants of a lower cadre, to the heads of the extra ministerial department, ministry, like permanent secretary, department, or agencies. So from level 1 to 6, those powers could be exercised by them as had been donated to them or delegated to them under the public service rules by the Federal Civil Service Commission. Because the Federal Civil Service Commission cannot be taking on
all the decisions
practically in cases of all sets of workers all over the Federation. Those are the people who have those powers. So when the president then directed that, we said, no, the president, you cannot do this. However, the president said, look, I'm calling the attention of the Federal Civil Service Commission to this audit. A person who was dismissed from service, there was no judgment directing that be reinstated, as I've explained. There was no case that was filed by him specifically on the issue of his dismissal against the Federal Civil Service Commission as a defendant, which then led to his being reinstated by another of court. So why have you then reinstated him? So I'm, as the president, looking at this, and I'm advising that look at the possibility of cancelling the purported reinstatement for its irregularity. So it will not then be a station in which the Federal Civil Service Commission will now say, oh, we take it as given that it's been properly reinstated. So for us to remove him again, we'll have to set up a panel to grab him, and then complicate the matter. So it is a simple matter of just using a ballot to cancel an irregularity. So that if he then wanted to go back to court to challenge his initial dismissal, he can do that. But of course, Mana knows, everybody knows, the AGF knows that I can't do that any longer. Why? Because there's a law called the Public Officer Protection Act that provides that if you are a public officer and you are sacked or a public officer has done something against you, you have to challenge that within 3 months of the cause of action arising, in meaning of the occurrence of that. So, Mana was sacked in 2013. He ran away. So, 3 months after that, his cause of action has been defeated. It had died. So my NAC are no longer going to go to challenge. So they know. So that's why they are manipulating the thing and then lashing onto all this.
Let's talk about the role that the Attorney General has played here. You've used the word here, irregular. Who do you blame here? Who brought Maina back? Who solely was responsible for bringing him back? Not only did they bring him back, they promoted him, and they asked that he also be entered into forthcoming exams for further promotion. Who do you blame?
I blame all those people in the chain. The AGF, the Minister of Interior, whose name was mentioned, the DGSSS, whose name was mentioned, and who came on the floor of the House of Representatives Committee hearing to say that we are the one offering protection. The NSA, that was part of the whole process of meeting in Dubai and all that. The Permanent Secretary in the Ministry of Interior, who offered his head as the fall guy and claimed that he was the one who was responsible for reinstating Maina, lying obviously against himself because he has no power to reinstate. The power to reinstate a dismissed civil servant lies with the employer. That is the Federal Civil Service Commission. So the Permanent Secretary is not the employer of any civil servant. So for that Permanent Secretary to then say of the cadre of an assistant director, to then say that I was the one who was responsible, he was not lying through his teeth. All these persons are responsible. However, the Honorable Attorney General of the Federation provided the enabling environment for that reinstatement to come. And that's why, in my judgment, his responsibility is the highest. He is the chief law officer of the Federation. Section 150 of the Constitution says so. And he has special powers under Section 174 of the Constitution.
He's the only minister mentioned separately in the Constitution.
Yes. Now, he was the one who provided a legal pretext, a legal ruse, a legal shibboleth for the purported reinstatement of Maina. That was why his office was the one that was writing those letters, issuing those directives, advising the other entities in the chain that this is what the law says. This is what the constitutional effect that is required to be given to a so-called judgment, for its reinstatement and all that. So he was the instigator. He was the initiator. He was the mastermind. He was the facilitator. And so, for me, there is no reason for the Attorney General of the Federation to do that. And when on the floor of the House of Rep, he was now being grilled, I wasn't happy. I'm telling you.
Why were you not happy?
You know, I wasn't happy because the office he occupies is the head of the official bar. I'm in the private bar. He's the head of the official bar. The office of the Attorney General of the Federation is a very powerful office. There is no lawyer that should not respect that office. Now, for the person occupying that office to now be subjected to all sort of grilling by members of the House, many of them who are not even lawyers, to be told that you are wrong and all that, I wasn't happy. And I was scandalized when the DGSS said that the Attorney General called me on phone to seek my advice. That's heresy. It should be the other way around because you are the chief legal advisor. So, to seek his advice on whether I should meet with Maina in Dubai. And he then gave him advice that meet with Maina, but ensure that a third person is there. That's not a security matter. Say let a third person be there to hear what he's discussing with you. So, you are the master of the game. You surrender your own power to the head of a security service to be giving you advice.
What about the fact that Maina remained on the wanted list? Many have questioned, myself included, is there anything stopping the Office of the Attorney General from also seeking the advice of the EFCC, for instance, saying, this man used to be wanted. Is he still on your wanted list? Would that have helped maybe in his decision? Or
the EFCC Act by section 43 thereof is subject to the advisory of the Attorney General. Indeed, when I say the Attorney General is the chief legal advisor, so he may make rules, regulations for the conduct of the EFCC, and they share information. Don't forget there was a time Chief Obonobla was, up in arms against the FCC, condemning publicly. I thought that it should have been done privately, by discussion and collaboration in the media, accusing the FCC of defiance, of impudence in not sharing information with the Attorney General relating to the files of the SY governors who are undergoing trial, for 3 of them or so. Now, the Attorney General of the Federation has access to the FCC. Any information he wants can get from the FCC. As a matter of fact, his presentation on Maina, when he was reading all those things, were prepared from the report on Maina by the FCC. Report of the investigation. Because the Attorney General is not an investigator. So he couldn't have been saying all those things as if the information he obtained himself. No, the Attorney General is a prosecutor and advisor to the federal government when he decides to do so. That's what Section 174 says. He can take up cases and prosecute So, in other words, like the prosecutor general of the government. So, he is not the one that investigates. Therefore, the Attorney General at every point in time, when he was writing his letter, had access to the report by the FCC. If he didn't call for any file to be better informed before writing that letter, the main things, the assumption can be that he knew what he was doing, that he was just fixated on writing the letter.
You think he should be fired?
The Nigerian people didn't hire the Attorney General, and those who govern us do not take our opinions for anything, really. I have publicly stated that if I were the Attorney General over this matter, I would have turned in my resignation, because it was very scandalous that an Attorney General of the Federation could be meeting with a fugitive outside the shores of Nigeria and then could come into the country and start arranging for how that fugitive should be reinstated, thereby foreclosing the possibility of that fugitive facing prosecution. In a matter in which, don't forget, at least 19 persons were indicted and 12 of them include the former head of service, Stephen Oronsai. I've gone through the threshing floor of the judiciary. They've been tried right now. So this one was now brought back, demystifying the importance of the rule of law and the centrality of the principle or sub-principle of the equality of all before the law, inherent in that principle of the rule of law. So you brought him back, and then you wanted to bring him back into service until people got to know and started shouting. So once you cut like that, you just turn in your resignation. But you know, things don't work the way people think in Nigeria.
Yes. All right. Join us again after the break. Moments now with legal practitioner JITI OgUNYE. We've been following this SARS story, a special anti-robbery squad, in the news. Do you think, in spite of all these complaints, there is justification for scrapping SARS?
It's not just SARS that should be scrapped. I think that the entire police force needs redemption. It needs to be reformed. I think that what Nigerians are now being compelled to do is to now start picking SARS. There are several squads in the police force, especially anti-kidnapping squad, anti-pipeline vandalization squad, SFU, things like that. Yes. I think that the entire police force needs reform, and I think at this point that has been put forward. We need to restructure the police so that every locality, every state will have its own police force. There should be a law of general application that will set the standards, how this state police service commission should be constituted, ensuring that the governor of the state does not have the overarching powers to use the police force for that state anyhow. So all the sectors, including labor, the traditional institution, faith organizations, will have their representatives, and this will be statutory on that board. And so that police service commission for that state will then, so you do that, and then ensure that those who are recruited as policemen in every state, commit themselves to defending that state, if need be, with their lives, to ensure that law and order is preserved and that there is security of lives and property, and that crime is reduced to the barest minimum. I think that that's what we need to do. This whole idea of having a unitary police force under Section 214, 215 of the Constitution in Abuja, and then all sorts of squads are created, and then they are called upon to be doing stuff, it's not going to work. So it's a fact that SARS has been known to be notorious. They engage in extrajudicial killings.
I've been trying to interview some of the young people who have had dealings with SARS. Many of them are very scared to come forward. Many parents don't want them to speak on camera. For the sake of those parents, I just want you to clear for us. Is it a crime to wear jeans, or to carry a rucksack, or to carry your laptop or your iPad around with you?
It's not a crime. You know that in this country, policemen have been known to be armorers of armed robbers. Policemen have also been known to be armed robbers themselves. There was an incident in Kogi State where a police team robbed some passengers of their money. They had an accident. Instead of saving them, taking them to the hospitals, they robbed them in that state and they set the bus ablaze. As if that accident led to an infamy and all that. They were caught and they were sentenced to death. So we have such incident in the police force. Now, all over the place, you see young people riding motorcycles, Okada, and they are stopped, and then the policeman will say, bring your phone, and then they will be flipping through the phone.
Yes.
Yeah, who is this? Who do you talk to? You are a Yahoo boy. See the way you freeze your hair.
Yes.
See the way you dress.
Yes.
And start extorting money from them. In Lagos, policemen have been known to have engaged in robbery, holding on to people and then forcing them to go to their ATMs to go and withdraw their money. So Nigeria is a huge crime scene, and I'm not proud to say this. So if policemen that are employed to enforce the law then become the lawbreakers, then where do we go?
What is the legal redress? I'm a mother of young boys, and their friends come and ask me, and I say, you can sue. But am I right?
You are right. They can sue. If we have such people, and we have pro bono services.
Yes.
There is the Office of the Public Defender in Lagos, and there are other, organizations that can take up this matter against the police.
Yes.
And sue them. But that's only one aspect of the matter. Under the Sheriff's and Civil Process Act, there's a section that says that if you obtain a judgment against a state official and you want to claim that judgment, the Attorney General must sign off on it and permit you to enforce that judgment. Somehow we've been trying to navigate because there are some cases where we've gotten judgment and we got the judgment sum, regardless of the fact that the state is involved.
They do pay the sums?
We forced the hands of the state on those occasions. For example, there was a case in which we won 8 million naira for a young Nigerian, a small boy, who was blinded by the police, who shot at him in the course of quelling a riot in Lagos. And so we went to court and we got judgment against Operation Sweep in those days, the precursor of RRS, Rapid Response Squad, which is an hybrid force, including policemen, soldiers, and so on and so forth. And when we got that judgment against the Lagos State government, they didn't want to pay us. So we filed a garnishee action in court, and we garnished the 8 million naira in the account of the Lagos State government in Eco International Bank. That was before the merger of the bank, before the consolidation of the banks and all that. And we got to court. And the argument of the state was, Section 85 or 86 of the Sheriff and Civil Process Act says that you can't do this because this money belongs to the state and the Attorney General has not signed off on it. So this money is in the custody of the state. My argument on that occasion was, look, this money is not in your custody. It's in the custody of the bank. The bank is a commercial entity, so the bank is not the state. So this money can be garnished. And I used an analogy at the court, and I told the court that, look, Judge, you sign a detention order, and then you ask a criminal defendant to be remanded in prison custody. That criminal defendant is in prison, is in the custody of the prison. Yes. So the fact that you are the one who signed the detention order does not mean that is in your custody. So the Accountant General of the state will be signing a check of the state. The Commissioner of Finance will even be signing that check. But that doesn't mean that the money of that state is in the custody. Custody means the person who has it, and that custody is the bank. So it was at that point that they said they wanted to settle, and then they gave us the judgment, so the money. So we can be creative about this. Yes. Force the hands of the states to get this money out. But that's part of it, the constraints. But regardless, we encourage people, as many as they are, that are victims of right violations by police, to come forward and then file actions against the police. Yes. Perhaps one of the things that the NSAS campaign should be doing is to encourage litigation, to inundate police force and use the slate of litigation to check the excesses of the police. And
I can't let you go without talking about this slavery in Libya matter, looking at the possibility of victims of that slavery too suing the government of Libya. Has Nigeria declared her acceptance of the jurisdiction of the African Court on Human and People's Rights? Is that going to be a pre-requirement for any Nigerian wanting to sue the Libyan government? Of course.
The question of suing the Libyan government within Libya does not arise because the country is in a state of flux right now. Yes. So the AU mechanism, the African Court mechanism, could have been used, but Nigeria has not signed up to it in terms of adopting the charter. And without doing so, Nigerians from Nigeria cannot access the jurisdiction of the court to enforce their rights in Libya. But beyond that, let me just say generally that a country that drives its people to adopt desperate solutions ought to have a rethink. As you go to the embassies everywhere, you see Nigerians trooping there. Yeah, they will just want to escape from Nigeria, since Nigeria is a war zone. So our country has become so hostile that our people are ready to trek the entire length and breadth of the Sahara Desert to get to Europe. And so it's something that our government has to seriously think about. So it's not just sufficient for us to put plane on the ground to evacuate our people from Libya and other parts of the world and all that. Our government must find a reason why our young people are trooping out of the country. And the reason is not far-fetched. A whole huge industry has emerged to cash in on the desperation of Nigerians to get out of the country. Churches, religious centers, people even advertising on radio that they can pray for you to obtain visas. And people celebrate when they obtain their visas, that God has done it, that they've been on it for 2, 3, 4, 5 years, but eventually God has done it. So that's how desperate our situation has become. And I think that we must work to ensure that our home is no longer hostile to us to such an extent that in droves our young people are fleeing from our homes into the uncertainty of economic exile without knowing what awaits them there. What's going to be their fate in those countries? We must work seriously to combat those things that drive our country to adopt this kind of desperate solution and then perish elsewhere.
Thank you very much,
It's my pleasure.
For coming on 60 Minutes with you. It's always a pleasure to have these legal discussions with you. Thank you. And thank you for watching. I'm Angela at JITI Ogunye.